Welcome. Thank you for coming tonight. It's great to see everyone here. My name is Anthony Tregoski. I'm from the Political Science and Public Administration Department here at the University of Wisconsin-La Crosse. And we're so pleased to see all of you here tonight to this town hall meeting on the issue of judicial recusal and voter turnout in judicial elections. This town hall is organized by Common Cause in Wisconsin. Common Cause in Wisconsin is the state's largest nonpartisan citizens reform advocacy organization, and it boasts more than 7,500 members and activists around the state. It is occurring, this town hall, to educate the public about issues related to judicial recusal and turnout in state elections, in part because the Wisconsin Supreme Court refused to hold a public hearing on the issue in 2017 when it last considered the issue. Common Cause of Wisconsin organized 3 town hall meetings on the issue since then in Green Bay, Milwaukee, and then in Madison. And now tonight here in La Crosse. Citizens around the state deserve to be made aware of the issue and why it's important, and they were denied an opportunity to weigh in on the matter before the Wisconsin State Supreme Court itself. So co-sponsors of this evening's public hearing include the League of Women Voters of Wisconsin, the League of Women Voters of the La Crosse area, the American Association of University Women of Wisconsin, La Crosse branch, as well as by the University of Wisconsin-La Crosse Political Science and Public Administration Department. The UW-La Crosse Political Science and Public Administration Student Association is another sponsor, as well as the UW-La Crosse Pre-Law Society. And this event is made possible due to a grant by the Piper Proteus Fund. We will begin with my introductions of the panelists and opening statements by each of them, and then we'll open it up to the audience. And the audience, all of you, will be invited to participate with questions or statements of your own about the issue of judicial recusal and judicial elections. So I'll start by introducing myself. My name is Anthony Tregoski. I'm a first-year professor of political science here at the University of Wisconsin-La Crosse. My research and teaching are focused on American political institutions as well as campaigns and elections. I have a PhD in political science from the University of North Carolina at Chapel Hill, and I'm a native Minnesotan. I have a bachelor's degree in political science from the University of Minnesota. Dr. Richard Kyte is the endowed professor and director of the D.B. Reinhart Institute for Ethics and Leadership at Viterbo University in La Crosse. He teaches a variety of ethics courses dealing with issues in business, leadership, and the environment. He received his undergraduate degree from Hamline University and his PhD in philosophy from the Johns Hopkins University in 1994. Rick writes a regular column for the La Crosse Tribune titled The Ethical Life, and he also serves as board president of Leader Ethics Wisconsin. Judge Dale Pasell served as circuit judge for La Crosse County from 1999 until his retirement in 2014. He was elected 3 times. He was an associate dean and faculty member at the Wisconsin Judicial College from 2005 to 2011, and he was an adjunct faculty member at Viterbo University from 1997 to 2005, teaching criminal justice and constitutional law courses. Judge Pasell served as an assistant district attorney in Greene County from 1978 to 1979, and he was in the Wisconsin State Public Defender's Office from 1979 to 1999. Judge Pasell earned his bachelor's degree from UW-Madison in 1975 and his JD from the UW Law School in 1978. In addition to his current full-time role as a grandfather, Judge Pasell sits as a reserve judge and works as a mediator and consultant. Judge John Perlich was elected to the La Crosse County Circuit Court in 1985 and served in that capacity until 2006. He was elected as a part-time municipal judge for the city of La Crosse in 1983. He was a practicing trial attorney in La Crosse for 12 years upon his graduation from the Drake University Law School in 1973. Judge Perlich helped start and then presided over the La Crosse County Drug Treatment Court. The State Bar Association named him Judge of the Year in 2003, and the Wisconsin Association of Drug Court Professionals named him their Person of the Year for 2007. Erin Grunze is the Executive Director for the League of Women Voters of Wisconsin, a nonpartisan grassroots organization advocating for active and informed participation in government. She joined the League in 2016 as their voter education coordinator to increase voter service outreach in Wisconsin by working closely with the 20 and increasing local leagues. Erin's work now includes advocacy on issues for voting rights and good government, including fair courts and fair maps. Erin is a longtime Wisconsinite as well as a UW-La Crosse alum. She lives in Madison and enjoys taking her 2 young sons with her to vote. Jay Heck has been the Executive Director of Common Cause in Wisconsin since 1996. Prior to his tenure there, he served as a top assistant to State Senate Majority Leaders Joseph Stroh of Racine and Scott Helbach of Stevens Point. He moved to Wisconsin in 1988 from Washington, D.C., where he was legislative director for former U.S. Congressman Peter Kosmeier of Pennsylvania for 7 years. He also served on the staff of former Republican U.S. Congressman John Anderson of Illinois and served as a top aide and organizer in Anderson's 1980 independent candidacy for presidency of the United States. Heck is a graduate of Miami University in Oxford, Ohio. And now I'd like to turn it over to Jay Heck to set the table for the evening.
Anthony, thank you so much for those great introductions, and it's a pleasure to be here. This is the 3rd time that we've held a reform forum of some sort at the University of Wisconsin-La Crosse, beginning in 2007. And this one is on a little different subject matter, but one that's very timely and equally important. It's great to see Chancellor Goff here. It's wonderful to see our former moderator who did our last moderated our last event, as well as the legendary Joe Heim, who moderated our very first event back in 2007, and many familiar faces and friends, including Common Cause members and people in the League of Women Voters, and of course this very vibrant young contingent of students that we have up there. It's really nice to have you. What we hope to do tonight is educate you a little bit about the importance of this issue called judicial recusal, but also about the upcoming Wisconsin Supreme Court and the importance of judicial elections in general. And I just want to start by saying that when I moved to Wisconsin from Washington, D.C. in 1989, Wisconsin was considered to be the model state in the country for its court system. Its Supreme Court was considered to be amongst the most impartial, excellent, well-argued, and intelligent of Supreme Courts in the country. The courts at every other level were considered to be models for the rest of the nation. I hope it's not coincidental with the fact that I've been here since that time, but since that time we've seen, I have to say, a deterioration, not just in the quality of some of the courts, not all, but some of the courts in this state, but also in our politics and our state government. The issue that we want to talk about tonight became very important really about 10 years ago when we saw the first invasion of a lot of outside special interest money into our state Supreme Court elections. That happened in 1997. Prior to 1997, Supreme Court elections in Wisconsin were really truly nonpartisan. Usually a candidate for the Supreme Court had a governor of both political parties on their letterhead, and they were judged according to things like judicial temperament, according to their qualifications, the ratings by the Bar Association. That changed over time, but certainly in 1997 we saw a whole different dynamic. We saw a tremendous amount of outside money come into the elections for the state Supreme Court, and that continued and has continued in almost every Supreme Court election up until that point. And one of the things that you need to be aware of is that with all of this outside money, you would be surprised to note that the state of Wisconsin has the 47th weakest recusal rules in the country. That is to say, we require, or we do not require, judges at any level to recuse themselves from a case in which a campaign contributor has contributed a significant amount of money, or they have been the beneficiary of outside money, which is really, if you think about it, a huge conflict of interest, and we're going to get into that a little bit more tonight. I should mention to you that the state of Illinois, Cook County, Chicago, has stronger recusal rules than we have in Wisconsin. The rules we have in Wisconsin were written by two special interest groups, the Wisconsin Realtors Association and Wisconsin Manufacturers and Commerce in 2010, and adopted verbatim by the conservatives on the Supreme Court. And the reason, and the recusal rule is self-recusal. A judge decides for themselves whether they should sit off of a case in which one of the parties before them gave a significant campaign contribution or engaged in heavy outside spending on behalf of them or attacking their opponent. So that's a huge conflict, and it continues to this day. It's been a tremendous issue in past Supreme Court elections, and just in the last several weeks, it's become a very big issue. When you may recall that one of the candidates, Lisa Neubauer, it was announced that an organization run by the former Attorney General, Eric Holder, who was the Attorney General under President Obama, was going to come into Wisconsin and spend $350,000 on her behalf. There have been special interest groups that have said that they were going to spend heavily on behalf of Hagedorn, Brian Hagedorn, who is the conservative candidate for the Supreme Court. Two of those special interest groups, ironically the two groups that wrote the recusal standard that we have in Wisconsin in 2010, just a month ago, said they were not going to be participating in this outside spending, really based on the odious comments that Judge Hagedorn made about the gay, lesbian, and bigender community, transgender community in the state. And so the Realtors and Wisconsin Manufacturers and Commerce withdrew their support. There are several other groups, though, that are weighing in: the National Rifle Association, Wisconsin Right to Life. And Judge Hagedorn has said he doesn't think it's necessary for judges to recuse themselves. It's a First Amendment issue. Judges should be able to spend freely. Judge Neubauer, on the other hand, even though she is now going to be the beneficiary of about $350,000 of outside money from Eric Holder's group, has wisely, I think you'll agree, said that she would recuse herself from any case in which Holder or his organization were to appear before the Wisconsin Supreme Court. So that's the issue we're talking about with regard to recusal. And I'll just touch briefly. You know, judicial elections in Wisconsin are kind of unique. They're always held in the spring. The turnout is always very low. And turnout means everything in these elections. They're traditionally as low as about 10%. Last year, turnout was as high as 20%. And it made a huge difference, not only in the number of people that voted, but really also, I think, in the election results. And so I think what's important, if you take nothing else away from this, this evening tonight, is that your vote in a spring election, and that's April 2nd, by the way, carries a lot of weight. It carries, if you think about it, even more weight than your election for governor or president, because there's fewer people voting. And so your vote really does make a difference. So I hope you'll digest some of this information tonight, go out and talk to your friends and neighbors, ultimately convince the Wisconsin Supreme Court that they need to adopt stronger judicial recusal rules. And I thank you again for coming, and I look forward to hearing what you have to say after the five of us are done. Thank you.
Well, as Jay mentioned, a key part of the reason for recusal rules is to avoid conflict of interest. And I just want to say a little bit about this, because this is where professional ethics comes into this matter. Recusal is all about conflict of interest. And in just about every profession in the United States has a code of ethics, and one of the key elements of the code of ethics is avoiding conflicts of interest. And there are three reasons for that. The first is to prevent corruption. The second is to reduce personal bias in both decision-making and activity. And the third one is to protect the reputation of the profession. It's pretty obvious why we would want to prevent corruption in our judicial system. And if any of you think that our judicial system is just immune to potential for corruption, I would think that's kind of naive. And so why not eliminate potential for conflict of interest and prevent possible corruption? Second is personal bias. What we found in all kinds of studies about bias is that all of us are much more susceptible to bias than we think we are. And education does not make us less susceptible to bias. In some ways, it makes us more susceptible to it. We find more ways of rationalizing the decisions that we would want to make anyway. An example is a study was done a number of years ago about first and second year medical residents. And they were asked, does receiving money or promotions from pharmaceutical companies affect their judgments on what to prescribe? Only about 5% thought it would, but when they were asked, does it affect what other physicians prescribe, over 50% thought that it did. That we're much more likely to think that these kinds of influences affect other people's judgments than our own. And so this is why most professions want to reduce potential for bias. The third thing, and really the most important reason that professions want to eliminate conflict of interest, is that it protects the reputation of the profession when you've done all that you can to say outside influences aren't going to affect what we do professionally. And if you look at the professions that tend to take this most seriously, professions like physicians and nurses, engineers, accountants, they have really strict rules on conflict of interest. It just amazes me that our own justices don't see the necessity of protecting the reputation of their profession, especially since so much of the very function of our judicial system depends on its reputation. And so I would just end with saying this. If we think it's important to avoid conflict of interest in just about every other profession, why not apply the very same standards to our justices?
I think that people might rightly ask, is justice for sale in Wisconsin? If you look at the campaigns over the last decade plus, especially at the Supreme Court level, you would see that in all of those campaigns we have had over $1 million spent. On 3 of the campaigns, I believe there was over $3 million spent. In the campaign in 2011, there was over $5 million spent. And in the face of all of that, people perceive, and I think understandably, that the parties who are contributing this money are buying influence with the people who are going to sit in judgment in the cases involving their clients or themselves, that kind of thing. And so it's important that we have strong recusal rules. Judge Perlich and myself were among the 54 judges that petitioned our Supreme Court to strengthen the recusal rules in 2017. The rule we have now is essentially that the judge who is being challenged as biased decides whether they're biased or not, does not have to give a reason. There's no review of that judge's decision. And so really it is aimed at subjective bias, whether the judge himself or herself believes that they're biased. And if they don't believe that they are, they can go ahead and sit on the case. But the case law that we have in this country makes clear that it's not just a test of subjective bias, it's an objective test, whether somebody looking at that judge and looking at the issues involved, how much money was contributed, the relationship of the judge to the case, might feel that that person was actually biased. Because the law requires and due process demands that every citizen who comes into court is entitled to a fair and impartial tribunal. They're entitled to a fair and impartial judge. And you can only imagine what you might feel like if you came to court and sitting across from you, your opponent in court had contributed $3 million to the judge who was now deciding your case, and whether you would think that there's some possibility that that judge might be influenced by that kind of money. And so we want to see whoever is elected to the court, we want to see this revisited. We want to see stronger recusal rules put in place. You know, we want to see some principles followed in terms of having those kinds of recusal rules. First, we want their recusal decisions to be written or made on the record with the reasoning for the decision put forth so that it can be reviewed. Secondly, we want to have somebody other than the judge themselves decide whether or not recusal is appropriate. That can take a variety of forms. Some places they actually, the motion doesn't go to the judge involved. The motion goes to another judge right away. Some places they let the judge involved make a decision, but if the judge says, I'm staying on the case, that's subject to review again by another judge. So we'd like to see that as well. We also want to see in any kind of recusal rule that there's some kind of mandatory disclosure, putting the burden on the parties to notify the court whether or not they have contributed or their lawyers have contributed money to the campaign so that the court can know, because right now there's no way to know. A lot of the campaign money that's involved comes through independent parties, and there's no mandatory disclosure of who the sources are. So those principles have to be honored. As we go along this evening, I can talk a little bit about some of the case law involved in this. There's a very important decision of the United States Supreme Court from 2009, Caperton versus Massey, that for the first time said that the failure of a judge to recuse himself in a case, and this involved the West Virginia Supreme Court, the failure of a judge in that case who had gotten $3 million in contributions, which was more than all of the other campaigns combined, I mean, more than anybody else, that judge wouldn't recuse himself, that could amount to a due process violation and on federal constitutional law, because it deprived a person of having a fair and impartial judge to hear their case. So we can talk about that as well, but we're here because we think that when you vote, and certainly voting is important when you come to courts in Wisconsin, and we want to see you vote. But when you vote, we want you to be informed about the candidate's position on recusal rules. And so as we discuss this today, that's something that we would like you to consider when you make your decision about who you're going to cast your ballot for. Where does that candidate stand on the issue of getting biased judges or judges who are perceived to be biased because of the amount of money they've received off of a case?
Mr. Perlich? Okay. I'm the token conservative here amongst all these intelligent liberals. And the reason there's liberals and conservatives here is because this is such an important issue. Doesn't seem like it until you understand the background, and I hope we can go back and Dale can tell you some of the facts involving that Supreme Court case, the Carrington Case, which are so drastic. And in result, the result of that case was where the Supreme Court of the United States said, look, there are some things that reach a constitutional level when it comes to the appearance of impropriety. And in response to that, 40-some states of the United States changed their rules on recusal. They made it much, much tighter on when a judge has to recuse him or herself. One state didn't. One state, Wisconsin, our state, changed the rule to make it easier. A judge, and only the judge decides if he or she should step down, and it's not reviewable by anybody. One state out of 50 changed the rules that way, and it's our state. And that's why a lot of the retired judges and justices of the Supreme Court filed a petition with our Supreme Court saying, we gotta do something about this. And the court summarily threw the petition out, didn't even set it for a hearing, wouldn't even give us a hearing. 2 points I wanna make. One is that nobody is saying there's a lot of judges in the state of Wisconsin that are taking campaign contributions and then ruling in favor of litigants who gave them those contributions. We are not accusing anybody of direct conflicts or anything like that, but it's the appearance of a conflict. It's the appearance of an impropriety. It's the appearance of whether or not the case is being fairly decided. And if there is that taint, if there is that appearance that something is wrong, then it is wrong. If somebody thinks they lost their case because the judge received a campaign contribution from the other side, then to that extent, we did not give that litigant a fair and impartial hearing that he or she deserved. The other part of that, folks, is that look at the institutions that we have and the respect we have for those institutions. And all of those institutions have taken severe hits over the last few years. Does anybody really respect the House of Representatives or the State Senate? They have the lowest ratings in history, less than 25%. You look at the institution of the Catholic Church, and now it all comes out that bishops and archbishops were hiding sex offenders. I don't mean to take a shot at colleges, but I will. We now have some very prestigious universities that are taking bribes to let people in to those universities. Where do we have our faith in our institutions? And my point is this: there's still, I hope, a fair amount of faith that we have in the judicial system of the United States. And it's time for us to do whatever we possibly can to make sure that that belief is still fresh in everybody's mind. And if there is a way that we can change this recusal rule to make people feel better about the judicial system, I'm in favor of it.
I'm the least legal-minded one up here, and but the reason that I'm here is because I represent the League of Women Voters, and we are a grassroots organization harkening back to 1920, founded 6 months before the ratification of the 19th Amendment, which gave women the right to vote. And our organization is a grassroots organization, and we do believe in government. And we believe in the intricacies of the checks and balances and the systems that is supposed to support the rights of individuals. And so everything that the panelists so far have said concerning fairness, transparency, perceptions, accountability, those are the things that our organization monitors and tracks. And over a period of time, we study these issues closely, and we develop positions, and one of our positions includes the administration of justice. And so because of this position, the League in 2009, after the Caperton-Massey decision, decided that we would approach the Supreme Court with a petition asking for stronger recusal rules in Wisconsin. And as they have mentioned, that petition was denied, and instead the Realtors Association and the Manufacturers and Commerce petition was instead adopted. Then in 2017, the 51 judges? 54 judges petitioned the Supreme Court again, and we supported their decision to do so, again, asking for stronger recusal rules, and we're again disappointed by the Supreme Court's unwillingness to even give it a hearing. And so we continue to advocate and educate on this issue. Those are two of the areas that the league believes in, to educate voters and to help them cast informed votes. And then also to advocate and to tell our governing bodies and the representatives that we choose to represent us, why these issues matter to us. And we believe that the public confidence in our court system is important to a healthy democracy. One of the ways that we do this is through a voter's guide, and so in this spring elections voter's guide, we asked the candidates of the Supreme Court, both of whom replied to our questions. Would you be in favor of the adoption of the Supreme Court of standard rules requiring the recusal of judges from cases involving a major campaign contributor or supporter? Why or why not? And if you go to vote411.org, you can read both candidates' responses. We print them verbatim, and you can compare the response to that and 3 other questions that we asked those candidates. So it's important to know where they stand on this issue, as well as others that we ask. As they mentioned, money in politics is a problem, and we've seen a big influx of that money coming into our state for Supreme Court races, and this is one way that we can help disclose and make that a transparent process. As Jay mentioned, our next election is April 2nd. And I know there are a number of league members here, and there's some information out on the table about how you can vote. We also put together some fact sheets about what the Supreme Court does, how it can affect your everyday life, as well as the appeals court. And then many of us will also have district court judges we will also be voting on. Wisconsin is unique in that we do have this incredible responsibility to elect judges, and that it's not based on a selection process. And so it's a real responsibility and right that we need to take on and make sure we're going and casting our ballots and making our voices heard. And as Jay mentioned, the voter turnout is generally less in the spring, and so it's a good opportunity for you to take a friend with you and go to the polls.
Well, thank you to our panelists for those thought-provoking opening statements. And I'm going to open it up to the audience for questions in just a moment, but I thought I'd kick us off with kind of a big picture question and sort of a theme, sort of an assumption that's underlying our discussion about recusal rules is that, I think a couple things, that the judiciary in Wisconsin plays an enormously important role in the state's political system, and that confidence in the judiciary matters. And I'm wondering if I could kick things off by just asking the panel to comment sort of big picture on, one question that I get a lot is why does the judiciary matter? Why should we care about the judicial system in Wisconsin? So if the panel could kind of talk about the broader importance and the role of the judiciary in Wisconsin, and then why public confidence in the judiciary matters. So I'll kick it off with that, and raise your hand if you have a question. I'll hit you with the mic.
I'd like to hear from the judges.
Well, if you look at the impact of courts, virtually everybody at some point seems like they end up having something that goes through the court system. And circuit court judges in Wisconsin are judges of general jurisdiction. By Supreme Court rule, we handle basically all kinds of cases. And so Judge Perlich and myself have handled everything from small claims to homicides, from major medical malpractice to juvenile cases, from probate to adoptions to criminal cases, you name it, and we've done them. And all of those things have an impact on the lives of the people involved. You know, one of the things that I think really struck me when I took the bench was that cases that might not seem very important to somebody who's in the court system, relatively speaking, to the people involved, they're huge. They are big deals. It might be the only time this person has come to court. But your decision has a real impact on them. And every decision you make has an impact on the people involved. It might have an impact on other people as well. And certainly, we saw, you know, the average cases. The appellate courts, they set rules. They clarify the law. They tell us what the law is. The Supreme Court tells us what the law is. And virtually everything that goes on, at some point, somebody wants to litigate it. I mean, you pick up today's paper, and I'm sure there's something about somebody who's going to take something to court. So they make decisions that are very impactful on people's lives. And so, you know, in terms of its importance, I think it's clear. I do want to say this, that respect for the integrity of the court is paramount in making sure that judicial decisions are followed. When people feel that decisions are not being based on fair and impartial judges, and not being made by fair and impartial judges, that strikes at the heart of the judicial function. And so, to the extent that this perception is growing, that the system is, that these people aren't making decisions based on an application of the law to facts in a neutral way, it diminishes respect for the court. And whether you're a conservative or a liberal, whether you have one type of judicial philosophy or another, if you want to have court decisions that are honored, then you need to make sure that they deserve the respect of the people. And that integrity is lost when people see huge amounts of money that most people would look at it and say, that's got to influence somebody's decision.
I'll just add, in 2013, the Brennan Center did a pretty extensive poll on this, asking people, do they believe that campaign funding influences justices' decisions? And 87% of the respondents said they thought it does. That indicates a pretty big problem in the public perception of the integrity of our courts.
Let me just add one thing, and that is that former Wisconsin Supreme Court Justice Louis Butler is fond of saying that nobody cares about a judge until you come before one. And then when you come before one, you want the judge to be on your side. But failing that, at the very least, you want a judge who is completely impartial, who has no biases towards either of the parties before the court. And so you can imagine that if you are a party in a court case and the person on the other side made a sizable campaign contribution to the judge who is hearing the case, that you would feel as if you were at a slight disadvantage. And as has been said, the public confidence in even the appearance of corruption is paramount. We commissioned a question in a poll about a year, and it's about 16 months ago now, asking these two questions. And the questions were, do you think that Wisconsin judges should abide by stronger recusal rules in cases involving campaign contributions? The only thing that I'm amazed is that it was only 82% of the people who said yes. I can't really figure out who the 12% who said no were, but there were 12%. There you go, who would receive campaign contributions. And then the other question that went along with that is, do you think that campaign contributions to judges and to, for that matter, candidates for public office ought to be disclosed so that the public knows about them? And 83% said yes. And you should know that in Wisconsin, much of the money that now flows into our elections, both for judicial and regular elections, for the legislature and in other ways, is undisclosed. It's what we call dark money. So the public, obviously, is in favor of stronger recusal and transparency. The fact that the Wisconsin Supreme Court has not yet changed their recusal rules, I think reflects a direct conflict with the very citizens that it purports to serve.
All right, does anyone have a question or comment for our panel? Yes, ma'am, go ahead.
Thank you for your comments, and, I think at the basic issue is Citizens United, and as long as that stays in place, we'll always have an issue about contributions to any political office. And the transparency, how do you even regulate that if the judges themselves don't see a problem with that? And if we're gonna have elected judges, how do you get them elected if you aren't contributing to their campaigns? I mean, or you stop all campaign money to a judge, and they cannot accept any money, and they have to run completely on their own. So somewhere along the line, somebody has to step forward and start taking the money out of this, at least this part of our whole, our electoral system. So, so there's a lot of issues there, but I'd like to hear what your thoughts are.
I'll jump in with just one part of it. From 2009, for about 14 months in Wisconsin, we had 100% public financing for Supreme Court candidates in Wisconsin if they agreed to limit their spending to $400,000. And it worked well as far as it went. Neither David Prosser nor Joanne Kloppenberg in 2011 accepted any money, all of the money through direct campaign contributions, all the money that they used for their campaign was from public financing, which is, if you think about it, what it should be, because you don't want to judge, or judges don't directly solicit campaign contributions, but you don't want to have those special interest dollars flowing in. The problem with it was that it happened after Citizens United, and Citizens United allowed outside spending to come in. And so Prosser and Kloppenberg both were inundated and received literally hundreds of thousands, millions of dollars of outside money. It undermined, to some degree, the public financing aspect of it. And 2 months later, Governor Walker and the Republican legislature repealed all public financing for all elections in Wisconsin. But I would assert that public financing would be a good start.
Citizens United was a First Amendment case, a freedom of speech case. And obviously, the Wisconsin Supreme Court is not going to be able to change the United States Supreme Court decision. Citizens United's the law, and right now, at least, until another Supreme Court changes it, that's what's going to be. However, in trying to address some of those issues in the recusal petition that was filed by the 54 judges in 2017, we looked at trying to make sure that there was mandatory disclosure of contributions that was incumbent upon the lawyers and the litigants. They would have to advise a court if they had contributed, because there was no way to know, because there's a prior decision of the Wisconsin Supreme Court that says, there's no limit on coordination, and there's no mandatory disclosure. So we were trying to put into what we proposed, a rule that there would be mandatory disclosure by the parties. So that was one of the ways we tried to address it in the context of recusal and due process, the right to a fair trial. We could not address directly the First Amendment issues of speech, but I might say that a person's right to free speech, and if money is speech, money is speech. A person's right to free speech does not nullify another party's right to a fair trial. You have every right to speak. You can contribute all the money that you want And there's nothing really that we're gonna be able to do about that. But we can say that you don't get to pick the judge who's going to hear your case, and that judge, under certain circumstances where a certain amount of money's been contributed, cannot decide your case. So that in the context of that judicial decision, you know that the people who are deciding it are not being influenced by huge contributions. The larger issues that you're talking about are beyond the scope of what we could do. And I just might want to say that the 2010 decision of the Wisconsin Supreme Court to change their recusal rules by actually making them weaker in response to Caperton, where Justice Kennedy and Caperton had basically invited courts to make it tougher. We made it easier. We basically said no amount of money is a grounds alone for recusal. They had basically three rationales for keeping the rule that way. One was the law in effect at the time for direct contributions had relatively low limits about what could be contributed directly. Secondly, they said that there was no, since there could be no coordination with independent groups, there was no need to worry about the bias of the judge because they had no control over what these independent groups did anyway. And third was the argument that because the Wisconsin Constitution had no provision for the replacement of a Supreme Court justice when they were recused, that it would create enormous problems if you were to do that. When we filed our petition, we said, look, things have changed. First of all, in 2015, you raised the limits on what people could contribute directly by about 20 times. Secondly, in 2015, you issued a decision in one of the John Doe cases saying that, look, there's no limit on coordination between a candidate and independent groups, and there's no requirement that there be any disclosure by the independent groups of where their money's coming from. Third, in terms of the constitutional argument, there was very little problem, it seems, in the court to get the Constitution changed, to change the methodology for selecting our Chief Justice. And so what we proposed was, look, the rationale that underlies the 2010 recusal rule is gone. It's changed, things have changed. We now need to have these recusal rules that Justice Kennedy said you could do at the state level. And the Constitution should be changed to allow for, if a Supreme Court justice is recused, that another Court of Appeals judge could sit in their place for that particular case. And so that's kind of how we tried to address some of those issues. But Citizens United, that's a little bit, out of our lane.
One of the things that maybe we should go back and touch upon, and I'm not a historian, but the Supreme Court case, the Carrington case we're talking about, the facts of that case are, there was a lawsuit against the coal company. The coal company lost big time. It was a multi-million dollar judgment. $50 million judgment against the coal company. And of course, the old owner of the coal company didn't particularly appreciate that. And so he appealed. And it just so happened that there was an election, a judicial election for a Supreme Court justice that was going on at that time. And so he went out and found himself a candidate, if I've got that correct, and put in about $3 million in campaign contributions to get that guy elected to the Supreme Court to hear the case against his coal company. And guess what? That judge did hear the case and refused to recuse himself. And guess what? The case was overturned on appeal. The guy that he had gotten elected voted in favor of throwing the case out and saved the owner of the coal company $50 million. And it was appealed up to the Supreme Court of the United States, and they said, wait a minute, if it looks like a duck and it walks like a duck and it quacks like a duck, it's a duck, okay? And at that point in time, they said, that's wrong. And they reinstated or they turned it back.
They turned it back. to Ms. Schnick's question too, in that case, in the Caperton versus Massey case, of the $3 million that was contributed, only $1,000 was a direct campaign contribution because that was the limit in West Virginia. The other 2.9 million came through independent PACs.
Other questions?
My question is fairly simple. I haven't heard anybody talk about how these recusal rules are made. Is this legislative? Does it come from the court itself?
Come from the court.
And what is the mechanism for affecting change in these recusal rules?
Well, this is maybe one of those areas where both the legislature and the court have equal jurisdiction. I think, and others may disagree with me, that the legislature could pass a rule. They have no desire to do that. Nobody on the Assembly or the Senate has any guts to say, yeah, we want to step into this quagmire. And so the court itself has to do it, and that's why there have been petitions. That's why the petition by the retired judges went to the Supreme Court to change the rule, and got nowhere.
There's been two petitions. There was the 2010 petition, and then there was the 2017 petition. And I don't know if the legislature can do it. I honestly don't know. It's always, to my knowledge, been done by way of Supreme Court rule. And the Supreme Court can have a hearing and change their own rules, or their rules for operation. Interestingly, in the last petition, the 2017 petition, not only did they deny a public hearing, they heard the petition and said, we're not going to have a public hearing on it. They also instituted a rule that going forward, prospectively, hearings on the petitions themselves, whether to have a hearing, would be done in conference, private conference. So that those are no longer, at least we knew what happened in this one.
Right.
The next one, we won't know what happens, because it won't be public. And I think that the candidates for the Supreme Court have taken diametrically opposed positions on that. Judge Neubauer has said that was mishandled and favors having public, transparent hearings. And she has basically said she thought that there should have been a public hearing on the actual issue of recusal. Judge Hagedorn feels that because that would expose the disagreements in the court, that it actually has a negative impact on the court in terms of the view of its integrity, but that's how he's approached it. That's the argument he's made.
The only thing I'll add is that in 2017, in April, when the Supreme Court rejected the petition and further said we're not even going to hold a public hearing on it, the vote was 5-2. In April of 2018, as a result of that election, you could say now that it would be 4-3 if there were a vote taken on it. In the election coming up on April 2nd, that is to replace Justice Abrahamson, who was one who was very much in favor of having a public hearing and considering the petition. So just so you can keep track in the numbers, it would be 4-3 depending on what the outcome of the election is April 2nd, or it could be 5-2. And then April of 2020, because we have, if it's 7 of 10 years, every 10 years we have a Supreme Court election, will be the pivotal election. It will really be for control of the Supreme Court on a whole host of issues, but certainly on the recusal issue. And again, if the legislature can do anything, you're right, they have been, no one's stepped forward in the legislature to do anything about it. So it seems to be a court function.
Yeah, actually, I know that in 2017, there was an assembly bill introduced, and the league supported it, and I found it in our archives, because our previous executive director was really good about keeping records. So we have a statement in support of that bill, and it in particular was that that the parties making contributions must notify. So it's more of a disclosure of contributions, and so that would be a transparent and open information. So there is a way to do so through the legislature, but I think the league would support that the courts take it up upon themselves to write this.
If I could have a follow-up question. What's the mechanism for initiating a petition if none has been submitted for 9 years? And further, is each justice's vote in considering this issue, is that part of the public record?
It has been up until
Yes,
now.
right.
Because the hearing in the spring of 2017 on the petition that the 54 retired judges filed, that was an open conference, and so we know how they voted, and we know what they said. That will not be true, as I understand it, going forward. The next time a petition like this would be filed, they would simply have a meeting and decide whether to hear the petition, or whether to grant the petition and have a public hearing. So,
And you should explain, so the petition that the 54 judges, including these two, signed, was presented, rejected, so they would not present that same petition. My understanding is that, according to Justice Butler and others, is that at the judicial conference at the end of November, there was discussion about this, but there is no specific proposal or petition that's now before the Supreme Court or has been put forward, but that's not to say that one is not going to be written. But that shouldn't stop people from asking, I don't think, demanding at least a public hearing by the Supreme Court or by the legislature on the issue. I mean, that really is the problem with this. It's shrouded in darkness and secrecy. So certainly calling for a public hearing and continue to educate people, I think is something that's very important to continue to do.
All right. We have a mic coming your way, just a moment. Panelists, could you pull the mic a little closer? Folks in the back.
This is a question regarding the procedure of the hearing of the petition, or the rejection of the hearing of the petition, maybe that's the question. You said there was a transcript, so you knew the discussion of what happened. Is that correct, Judge?
Bonnie, the court has had a battle amongst the members for years on whether their conferences should be open to the public. There has not been a lot of argument about if they're deciding a case, those conferences should be closed.
Right.
Public shouldn't be involved in those. But when they are talking about a conference to talk about the rules under which we're going to operate,
Right.
and how much the dues are going to be, and you know, the appellate procedure, things like that, those arguments have always been vociferous, and sometimes they have allowed the public to sit in on those conferences, and sometimes they don't, and only they get to decide that. And for a while there, they were allowing the public to sit in on their conferences about rulemaking. And so when we filed that petition, that was under the old rules, where we had some of the judges who had authored that petition. They sat in on the conference, and
Okay.
they heard what was said and who said it, and they heard the vote and who voted, and we know which of the justices said, we're not even going to listen to this petition. You're not going to have a hearing. You're not going to have nothing. And we dismiss it immediately. And we know which justices really wanted to have a full-blown hearing before the court, on the record, and we know who won. We
Okay,
know who
thank you.
was.
Would a statewide advisory referendum carry any weight?
If you're asking me, I don't think so. I'm not optimistic about this issue. Now, maybe some of you are more politically connected than I am.
You know, that's a great question. In Wisconsin, as you may know, some states have what's called initiative and referendum binding referendum. California is such a state. There's others. Michigan, such a state. Ohio, where you can bypass the legislature. and not so in Wisconsin. In 2000, after I'd been a Common Cause for a few years, we had a referendum statewide on every ballot in November. Do you favor limits on campaign spending? Do you favor disclosure? In the case of Waukesha County, we even had, do you favor public financing of elections? 90% of the public overwhelmingly supported all of those things. I mean, it was a dunk, slam dunk. Nobody disagreed. The legislature ignored it because it's not binding. It's advisory, and the legislature doesn't like to take your advice often, as you know. So, nevertheless, I think it would be useful. Having said that, because it educates the public. And this is an issue that we need to educate the public consistently and constantly about. And that's when things will change, when enough people demand it in one form or another, either through the election, at election time, or, I don't know, storming the Supreme Court. I'm not recommending that, but I'm just saying that people have to become energized and vocal before change occurs.
Question? Mike's right there.
For Judge Perlich, what do your conservative colleagues in the judiciary, what argument do they make, saying that no, nothing here, nothing to see here, just go home, forget about it, nothing to worry about? What argument do they put forth? And for Judge Pasell, how would you rebut that argument?
On the trial bench, there are very few conservatives, to be perfectly honest with you. And the issue with the ones that are there is that we are trained to be impartial. We are trained to know what will sway us one way or the other. We are trained to accept the fact that it is our job to make a fair and impartial decision, putting out of our mind anything that's extraneous. And only a judge, he or she, can decide if in fact the outside influence is too strong. And so only the judge should make that call. Now, as Professor Kyte has just told you, that statistically we've shown that that's wrong. And the limit that we're talking about here, ladies and gentlemen, the petition we filed, or that our colleagues and I filed, set a bright line rule that if a judge had accepted $10,000, a justice had accepted $10,000 or more from a litigant, then that justice shouldn't, or the lawyer for that litigant, then that justice should not hear that case. Now, you may think that that was, a reasonable amount of money to make a bright line, but apparently some people didn't.
And it was less for each, like,
Yes.
Court of Appeals.
As you
circuit
went
court.
down.
It was 1,000 for circuit court judges.
Yeah, they didn't think much of us, so.
The argument that I've heard most frequently made in support of keeping the rule the way it is, with no amount of money being grounds for recusal if the judge himself or herself feels that they aren't biased, is the First Amendment argument that says, if people have a right to speak, they have a right to vote for who they want. Money is speech. They can contribute money to a judicial candidate, and that they shouldn't be deprived of having that judge then when the judge is elected from hearing cases. The response to that really is quite simple. Your right to speak doesn't nullify the opposing party's right to have a fair and impartial judge. Your right to speak does not guarantee you the judge that you want. And in fact, I think if you think about it, that kind of argument supports the position that we take that you need a stronger recusal rule, because why does the person want to contribute that money if they don't think that they're purchasing some kind of influence from the decision maker in their case? There's a reason why people are contributing millions of dollars to judicial candidates, because they think that it's important to them. And generally speaking, if you look at the people who are arguing against these recusal rules, they're the same people who feel like they've bought some influence when they've made these contributions. And so, this is about your justice system. And your justice system it depends on the respect of the public to have its decisions followed. And we aren't gonna have that if people think that the decisions are purchased, that justice is for sale. And so that's kind of nobody's taking away your right to campaign for whoever you want, contribute whatever you want, speak however you want, but you don't get to have that person decide your case, and you don't deprive the other party of a fair trial. That's the response that I think you
So it's gonna take a judicial solution to fix this, because the legislature's not going to.
Right, and back to something somebody asked earlier about an advisory opinion. Judges are elected, justices are elected, and public sentiment, they're not deaf and blind. The public sentiment, public thought, polls, at some point come to bear when you have people who are elected to public office. So, yeah, I think it was a great question, and I think that, I'd like to be a little bit optimistic about this, that if people start thinking about these things and people think they're important enough, that it's going to have at some point an impact. And I think Judge Neubauer, she's saying things about, she's not certain what the recusal rule would look like, but she's open to having a discussion about it. Justice Dallett, who was elected the last time around, similarly was willing to look at doing something about it. So I think that the public pressure to do this can have, in the long term anyway, an impact. And certainly, it's something that should concern every citizen when they're talking about what kind of judiciary they want and whether they want the decisions of that court to be respected. Seems to me, too, that if you have a majority on the court that you want, regardless of whether you're conservative or liberal or where you are on the political or judicial philosophy spectrum, you want the decisions, if you're the majority, to have the respect of the public. And so it seems to me that it would serve everybody, even people whose decisions you might not agree with, to have a recusal rule that was strong.
The justice that's being replaced is Justice Abramson, who voted for us. The next judicial election is to replace a justice who voted against us. So I am going to suggest to you that maybe the next judicial election, the next time the Supreme Court justice for the great state of Wisconsin is up for election, that might be the election that you want to watch.
We have a question over here. Just a moment. We'll have a mic coming your way.
I'm gonna walk real slow so I can ask one. So outside of being a retired judge, what can a normal citizen do to petition the court?
Well, the League of Women Voters did it once.
Well, the league did, and any group can bring a petition before the judge.
What does that entail, I suppose?
Well, it entails hiring a lawyer. for one thing. But let me just tell you that when the petition by the 54 retired jurors was submitted to the Supreme Court in early 2017, organizations and individuals, I think it was, well over 200, 210, submitted comments and common pleas of support or more sophisticated arguments as to why we needed that. There was only one entity that weighed in against stronger recusal rules. I won't say who it is other than tell you their initials were WMC.
But I mean, how many people need to be involved in order for a petition to actually be considered?
Well, that's a question I don't know. I don't know
I
what,
think one,
yeah.
I think.
I
mean, for
I'm
the
not
court to
certain of the
consider
answer
it.
to that.
Well, they didn't consider ours, but you can file a petition with the court.
Well, they considered it and decided not to hear it.
All right, we have a question up here.
What has the media done? Have they just been quiet recipients of the dark money, or have they actually taken a position in lobbying and being there and saying, yeah, this is the greatest thing since sliced bread?
As you may know, the editorial boards of this state have shrunk considerably in just the last 5 years. The La Crosse Tribune, the Wisconsin State Journal, the Capital Times, the Beloit Daily News, all of the Gannett papers, including the Milwaukee Journal Sentinel, as well as all the papers in the Fox Valley and northwestern Wisconsin, Wausau, Wisconsin Rapids, all of those owned by Gannett no longer A, editorialize in public policy issues, or B, will even be running opinion editorials written by other folks. That's the consolidation of the media. But in those papers that still do, there was unanimity for stronger recusal rules. And the Wisconsin State Journal, to its very great credit, has run a number of editorials in support of stronger recusal rules, and we're very much in support of the petition submitted 2 years ago. I'll say this as well. The issue of judicial recusal was a significant one in 2018 in the election, when Judge Dallett came out and said she supported public hearings, she supported consideration of stronger recusal issues, and her opponent did not. And it was in the body of almost every newspaper article before the election. It has started to appear, because it's been raised as an issue now, it's starting to appear in the newspapers now right before this election. And that was because, as I mentioned at the outset, the decision by Eric Holder's organization to put in $350,000, and then the decision by the realtors and Wisconsin Manufacturers and Commerce to pull out of the race. So the recusal issue has again come to the forefront. But the media coverage is nowhere near what it used to be in Wisconsin, and nowhere near what it should be.
And then, is Sinclair making an impact yet in our Wisconsin media?
Yeah, I don't know. I know they own some stations. I don't know.
If I could just follow up, I'm wondering if the judges could comment on kind of the importance of the press and the importance of the media in an accountable judiciary, and with the decline of the local media, does that concern you? Does that pose any threats to having an accountable judiciary?
And sorry, judges, before you answer, could I just have you pull your microphones a little bit closer? Some folks in the back are still having a hard time.
Okay. Let me think about how I want to say this.
I can buy you more time if you want this.
Use the mic.
Is it on?
You gotta be like, right, those are really for singing.
I think that we used to have far more extensive coverage, even of routine matters that came through our courts. And, when I came to La Crosse in the late 70s, cases that were being handled in court, there was a lot of newspaper coverage of them. Now it seems that it's fairly de minimis, except for the really high-profile cases. I've always believed that the more people see about how their courts function, the better off the court system is. Now, I think that the fact that people don't really know what goes on in court allows myths and untruths to propagate, whereas people who actually see the court system in operation generally come away with a better impression of the court system, having seen it, than they had before. We conducted polls of our jurors, for instance, and all the jurors who came in would fill out a questionnaire about what they thought about being selected for jury duty, some of which they didn't like very much. But almost to a person, we would see that their impression of the court system improved after having sat through a jury trial. And I think that the more people know about how our court system operates, the better it is for the court system. And so when we say we're going to have less coverage, it makes the court more of a mysterious place where people really don't understand how it works or what's going on, and that's not a good thing. In terms of accountability, Well, you know, we have our own system of accountability because litigants appeal. You have reviewing courts. You know, so every judge is cognizant of the fact that when you speak as a judge, you're addressing not only the litigants in court, you're addressing the lawyers, but you're also potentially addressing the Court of Appeals, you're addressing the victims. You're speaking to multiple audiences at the same time, and you have to be aware of that because what you're saying is being transcribed, and people are going to make decisions, you know, about you based on that. And so there is still accountability in that respect. And of course, you know, if you pick up the paper, if you say something that's outrageous enough, you'll get coverage. So.
There was a research study recently in the past year, I think it was, from some faculty at the University of Notre Dame on the importance of local press. And they studied the communities that had lost their paper, their local newspaper in the last few years, and found an increase in corruption at the local level in just about all of those communities. So there does seem to be a pretty strong correlation between clean government and good local press. Now, what we've seen in many communities is a decline in local coverage. But what we have to really watch out is if there is no coverage, right? Courts, but also city hall and everything else. The other thing is I've been for quite a few years serving on the editorial board of the La Crosse Tribune, and as you pointed out, we're one of the few remaining papers to still have an opinion page with the paper's own editorial comment. And we have been trying to interview candidates, not just for local elections, but for statewide. And we've been doing that with Supreme Court candidates for several years. This year, I don't think we've been able to interview the candidates this time, and I'm not sure why. But it gets harder to arrange. As fewer papers are doing this, candidates aren't traveling around the state to talk. This used to be something that was a normal part of running for statewide election, is you would go around and you would visit the editorial boards and in that way visit all of the communities. Now there are just very few communities that are doing that, and so there isn't the motivation to make that effort on the part of candidates.
Question? Right down here, then we'll go up there.
Judge Perlich, Judge Pasell, thank you for your honorable public service. We continue to elect you because both of you have been committed for a lifetime to the work of justice. The way in which you interact with each other, even today you continue to call each other Judge Perlich and Judge Pasell. Reverence is very much part of justice. I think that the dialogue right now of people running for the state Supreme Court is pathetic. It is not honorable civil discourse about ideas and the laws and our higher ideals. It's personal attacks, rhetorical, emotional. And the behavior of our justices towards each other in the last decade has been reprehensible. How is it that we help our justices recover a deep level of respect for each other so that the work of justice can be done for all?
I'll let my noted colleague, Judge Pasell, answer that question.
You know, I wish I knew the answer to that question. You know, your comments and observations, I think, are true not only of our courts here in Wisconsin, but of politics in general. You know, it's across the board, and it's not I guess, that amazing that kind of thing would infect even judicial campaigns at this juncture. I wish I knew. I wish I knew how we could make this work better so that candidates could talk about issues that are important. What's good for the people of our community? How do we better serve justice? And that we didn't have the kind of pervasive nastiness that seems to infect every election at every level now. I think the thing that's distressing to me is that when we see some of the kinds of things that are happening at a national level and at the state level start to permeate on down to smaller elections, and you see people thinking that that's the way you should do things. But I don't know. I don't know the answer to that question, I guess. I don't know if other people here have thoughts on it, but I really don't know.
I will add that I think the collegiality among the members of the court at the moment is getting a little better. You get a sense that maybe the atmosphere is improving a little bit, but I'm so far out of it and so removed from it because of retirement and distance, that I can't guarantee that. I'm optimistic about it. I do think it is getting better, but I can't prove that.
I agree with Judge Perlich's comments in that respect as well.
You have a question in the middle. All right, just one moment. Mike's on the way.
Currently, you said that Wisconsin ranks like 47th in the state in terms of recusal rules. Can you give us a snapshot of a state or states at the top of the list and what their recusal rules look like?
There are a number of, I can't name the states, but there are a number of states that have money limits on contributions that were put in place after the Caperton decision was announced. There are many states that now have independent neutral review of recusal decisions, so that if a judge says, I'm not going to recuse myself, another judge reviews that. There are a number of states that require the recusal decision to be articulated with reasons given. Most of the good recusal rules in the other states make it clear that it's not just the subjective opinion of the judge, that they are not biased, but that the standard is, as Caperton says, and even is in the preamble to our recusal rule, that a judge should recuse themselves when there's a reasonable person looking at the situation would think that there's a probability of bias. Those things are all lacking in Wisconsin's rule as it stands. And in fact, up until 2010, the rule was it was silent about money contributions, and now after 2010, after the league petitioned, the rule was actually weakened by making it clear that no matter how large the contribution, that alone was not a basis for recusal. So it went backwards instead of forwards. It was just an extremely disappointing decision. And as I said, the rationale for that rule has been undercut by subsequent changes in law, both in terms of statutes and case law.
Questions?
Any other questions?
I know Deb from the League of Women Voters has got a 45-minute speech she wants to make.
My name is Deborah Luchin. I'm currently the president of the League of Women Voters of the La Crosse area. And on behalf of the League, I would like to thank Common Cause for organizing it, and UW-La for hosting us, and of course the panel for educating us on this most important topic. The goal of the League, of course, is to empower voters and defend democracy, and that certainly is what we're talking about here. But right now, I'm going to take a small commercial break. That on behalf of the League, the Driftless Voter Coalition, and Friends of Vernon Fair Maps, I would like to invite you all to another opportunity to be prepared for the April 2nd election, and that is that On April 2nd, there is an advisory referendum in La Crosse County and Vernon County about fair maps. And so we are going to be having a panel. Erin will be returning back to meet with us again. And Tara Johnson, the La Crosse County Board Chair, and Matt Rothschild from the Wisconsin Democracy Campaign will be talking to us about nonpartisan redistricting, so that we're ready to answer the question, should the Wisconsin legislature create a nonpartisan procedure for preparing legislative and congressional redistricting plans?
Yes.
So that's an advisory referendum where we will be sending a message to our legislatures that we would like them to end gerrymandering now in Wisconsin. That event will begin at 7 o'clock. We will be at Viterbo University in their nursing auditorium, which is at 916 10th Street South. And if you go to the League of Women Voters La Crosse website, there'll be information there about it. But for over 40 years, the League of Women Voters has been advocating for a redistricting process that includes this drawing of maps by an independent entity. So if you'd like to learn more, to be prepared for that April 2nd question, please join us at Viterbo. And one more small ad, the League of Women Voters is open to men. We are not just women.
Boy Scouts.
Men and women over the age of 16 are welcome to join the league. University students, it's free membership. I have a sign up in the back. I'd be happy to take your name. Thank you again.
What's the date?
Oh, I'm sorry, Wednesday, March 27th.
Thank you. Panel, we're gonna kind of wrap it up, panel. Any final comments that you have, and, something that, I'd be sort of curious for you to touch on would be sort of the importance of getting out to vote in the upcoming election, what you'd like people to take away from tonight. So final comments from the panel, please.
There's an old saying, justice to be done must be seen to be done. I think that applies to this issue. So go out and vote.
I'll just add a couple of thoughts about what you can do. Writing your own representatives about the issue is a way to make them aware of your knowledge of it and what needs to be done on it. Papers do still accept letters to the editor, and that would be another way to help get the message out. Conversations, talking with those you know, and also taking a friend to vote on April 2nd is a good way to help get your voices out there as well. So I would echo the Go Vote slogan, and if you have any questions about doing that, you can talk to Deb and she can help get you set up on where you vote and how that needs to be done. And I think she brought a couple sample ballots too, if you need to look at those. But yeah, make your voices heard at the polls, but there's more that we can do beyond that.
Thank you for coming, particularly the students who are required to be here.
Strongly suggest.
Just judicial elections, they matter. This one, the next one, the one after that. And you'll get the judiciary that you deserve if you pay attention and vote appropriately.
A lot of life is just showing up, and if you don't show up to vote, then you're going to get the kind of things that you don't like about the system right now. And we know people don't vote in these elections a lot of times. So if you wanna change things, pay attention, make sure you get out there and vote, get other people to vote, because this is an opportunity to try to move things in the right direction. So thank you very much for being here.
And I'll end by saying thank you to Anthony, to the Political Science Department, to UW-La Crosse, sponsoring organizations, and mainly thank you to you by coming out here on arguably the first nice evening in months. You showed your commitment to democracy, and you know, it's turnouts like this, and this is a significant turnout to events like this that build movements. You know the Margaret Mead scene. All that it takes are a few determined people to affect change. That's not what she said, but that's just what she said. I always butcher that. But thank you for coming, seriously. And you know, get more information. Feel free to get on our email list, and we'll give you updates about our reform work, including fair maps, but fair courts and all the rest, and keep involved.
How about a round of applause
Thank
for
you.
our panel? Thank you, and good night.
Very stimulating on many levels. I just need to keep going.
Good to see you.